At the outset, I'd like to suggest that the clear implication of what the lower court did in this case, without really any extension, would require any person that owns property, any property interest with another person, whether it's co-ownership or life estate or an easement interest, where there's any type of a split or divided interest in the fee simple title with another person, and that person dies, the implications of the court's ruling in this case would mean that the surviving person risked losing their property rights unless a claim or cause of action is asserted against the decedent's estate within the 2-year period.
Well, how would you describe the use that Mr. Perez had in the property?
To understand that, you need to go, the divorce occurred in 2006.
I mean, was it a life estate? Was there a right to
No.
use?
Well, at the beginning of the story, Your Honor, the record shows without dispute that the property was jointly owned by Mr. and Mrs. Perez. And then the divorce proceeding came along in 2006. And at the inception of that, they owned the property jointly as tenants by the entirety. So under Florida law, each of them was deemed to have owned,
I'm just trying to get to the
owned
tail.
property.
What happened? Was there a new deed out from him to her?
There was, as a result of the marital settlement agreement, the property settlement agreement, and the final judgment that incorporated it, both of those documents expressly retained, Mr. Perez was ordered to quit claim the property to Mrs. Perez.
Okay, so there's the rub. I'm envisioning a deed from Perez A to Perez Moore B.
I quit claim deed, yeah.
Oh, okay. Was there a limitation on the face of the deed subject to his interest?
That's not on the record.
So it was just gave her the property and relied on the
What's
marital
that?
settlement agreement to enforce his use.
And the final judgment.
Okay.
And both the final judgment and the property settlement agreement directed Mr. Perez to quit claim the property to Mrs. Perez. But then right after that, both the MSA and the final judgment say, however, Mr. Perez shall retain the following interest in that property. So that's why I think it's important to start with the joint ownership, because he did not acquire anything from Mrs. Perez as a result of the judgment or the property settlement agreement. He owned the entire fee simple interest.
He did once upon a time, but to Judge Volante's point, I mean, you have to take the facts of the case that you're dealt, and he has divested himself of a possessory and ownership interest. What he has is a retained interest in proceeds from the sale of the NRA property.
And they retained possessory interest as well. There were two legs on that. And those two interests that he retained under the property settlement agreement and under the judgment were included in the bundle of rights that he would have had.
Is that part of his deck action? What is it, the 2 weeks a year he gets?
Yes,
Is
yes.
that part of the deck?
Yes.
The declaratory judgment action that you?
Yes, Your Honor.
Okay.
The MSA, the property settlement agreement and the final judgment are attached to and incorporated by reference into the deck action.
No, that's not what I asked. What I asked, did he seek relief vis-a-vis the 2 weeks a year to the?
Yes, he sought relief in terms of declaring and protecting and enforcing his retained property interest in the property, and that would include both of those components, the possessory interest and the right to receive a percentage of the profits upon the sale of the property. At this point, I'd like to jump to the controlling statute for a second, then come back to the facts, if I may. And unfortunately, in this case, it's de novo review. It's a dismissal with prejudice on motion to dismiss. So the facts are pretty simple and pretty clear and there's only one statute involved. So the last time I was here was on dependent loan revocation several years ago. And Judge Lucas wrote a long, lengthy scholarly opinion on that. And that thing was a nightmare as far as the record and convoluted. This is the polar opposite of that in terms of simplicity. So let me talk for a moment, if I may, about the controlling statute, which is 733, 710. And as you all know, that's the 2-year statute in the probate code, which the cases consistently call that a jurisdictional non-claim statute, a statute of repose. It's something that, if it applies, you really can't get past it. Fraud won't get you past it. You can't waive it. I mean, it's a hard deadline. And the language of the statute, which I think is extremely important, but what appellant's case is based upon is the main point is that under the plain and ambiguous language of that statute, it has no application to the facts of this case, and it was therefore error for the court to rely on that statute in dismissing the deck action with prejudice. The statute 733, 710, first of all, says this 2-year period protects the estate of a decedent, the personal representative of the beneficiary, and obviously the PR is the PR of that estate and the beneficiaries of that estate. But the key word is it protects the estate. And estate is a defined term in the probate code in the definitions in 731.201 sub 14. 731.201.14, estate is defined as the assets of the decedent that are subject to administration. And so the statute 733, 710, the 2-year statute protects estates. It doesn't apply to interests that are owned by someone outside of the estate. And the statute also, and probably more importantly, says that what it protects estates against are claims and causes of action against a decedent. So the statute has no application unless the claim or cause of action being asserted is one that was against the decedent, and it only protects the assets of the estate that are subject to administration. And the phrase in the statute that pertains to claims and causes of action against a decedent, claims is also defined in the definitional in the probate code 731.201.4 as a liability of the decedent. So basically 733, 710, the 2-year statute, involves the definition of estate in the definitional section and the definition of claims in the which is a liability of the decedent. So when you wrap that all together, the clear and plain language of 733, 710, incorporating the definitions in 731.201, says that the statute, the 2-year statute, only applies to a claimant that has a claim or cause of action against the decedent. And it only protects the estate, which are the assets of the decedent that are subject to administration. Now, let me get into the.
So are you saying the claim was against the property? To make the distinction clearer for me.
Yeah, Your Honor, I'm saying that the declaratory judgment litigation only concerned the appellant's retained interest in the property.
How is the interest retained if it's not on the face of the deed?
The interest is retained by the property settlement agreement and the final judgment that are attached to and a part of the complaint.
But that was an obligation of the decedent.
No, Your Honor, it absolutely was not. I'll try to work on that.
Are you trying to argue that a deck action isn't a claim for purposes of the non-claim statute? Is that what I read your argument in brief, I'll be honest, I had a hard time understanding.
I'm trying to say, what my position is that the claim and cause of action set forth in the deck action is not subject to the statute, that the statute has no application whatsoever to the cause of action that's set forth in a complaint for declaratory relief.
So you are not advocating that as a matter of law, a deck action is outside of the ambit of the non-claim statute?
Absolutely not.
Okay. Just what they're seeking a declaration of,
Right.
you believe is outside the ambit.
The fact that
It's just another way, it's just really just another way of saying you think this is a property interest and that it's not subject to non-claim statute.
not only is it a property interest, it's a property interest that the wife did not have, and it's and the deck action attempts to take nothing away from what the wife was given in the private settlement agreement or in the final judgment. And so basically, as far as the facts, we're down now to the divorce and the allegations of the deck action. Husband, the parties own the property jointly before the divorce. As a result of the divorce, the husband lost some interest that he had. And the husband retained some interest, but he lost and gave up more than he kept. And this is extremely important. At that point, based on that judgment and that property settlement agreement, there was nothing left for the wife to do. The wife did not have any unperformed obligations. She had no promises. She had no contractual obligations whatsoever.
She had a contingent obligation.
I'm sorry?
She had a contingent obligation. If the property sells, she's got to pay 20.
No, Your Honor, it doesn't say that.
He retains an interest in
He
25%.
retained the right.
What does that mean, other than he has a claim for 25% of the net proceeds? How else are you reading that?
He owns that interest in the property. He's retained it. And if the property is
It's an interest in
sold,
proceeds.
he goes to the closing table and he has to sign a conveyance to convey his interest and sign a closing statement. And the wife does. There's nothing in that agreement or judgment that you can
What do you
construe.
mean he has to, what do you mean what are you contending he would have to sign at a closing statement? And where is that in the record?
He retained an interest in the real property, and he doesn't lose that interest until he conveys it.
He's quitclaimed his interest.
He only has a contractual interest.
I'm sorry?
He only has a contractual interest. It's purely arises out of the contract.
His property interest, the effect of the contract was to take to give the interest to the wife and retain an interest in his part. His interest did not require.
Is that quitclaim deed any different than the garden variety, run-of-the-mine quitclaim deed that I
Yes,
see?
because the quitclaim deed in this case, as required by the property settlement agreement and the final judgment, is subject to the retained rights, so it's not conveyed.
Does it actually say that?
Yes, Your Honor.
It's on the face of the deed.
No, the deed's not in the record.
Okay, so,
The property settlement agreement and the final judgment are in the
well,
record.
just as a follow-up question, was a Liz Pendens filed? Was something filed of the public record that would have required him to go to the title company had there been a sale to sign off? The title company isn't gonna arbitrate a litigation between a contractual dispute, say, oh, we got a problem here. They're not courts.
No, but when they see the final judgment or the property settlement agreement, they will recognize that the husband has an interest, that the appellant has an interest in the property that has to be conveyed.
Well, that's a matter of opinion. I mean, I beg to differ, having written title policy when I was an attorney, I wasn't obligated to read the judgment unless the judgment conveyed an interest in a legal description. That's different. So does the judgment convey an interest in a legal description?
It retains an interest with a legal description.
And that's recorded, and you're saying therefore the title company had notice.
Yes, it would. When that judgment is recorded, it would be indexed and a title examiner would find that.
Let me see what the other side says about that, because that's an interesting argument.
Now, once the divorce was done, the property settlement agreement and the final judgment were the 2002-06 timeframe. The next fact that's in the record from the deck action, allegations of the deck action, are the wife dies. So that there's no issue or problem whatsoever at any time between the divorce and the documents attached to the deck action and her death. So then, after she died, her personal representatives came along, and this is alleged in the complaint, and questioned or challenged the interest of the appellant. So the deck action was filed by the appellant to determine that he still owned an interest, and that's where the motion to dismiss came along. So, and I think for your questions, the challenge that I see is, and I think this is extremely important. If you look carefully at the final judgment and the property settlement agreement, there is no promise, agreement, undertaking of any kind that the wife has to do after the date of those documents with respect to this property.
I don't want to interrupt you, but you're down to 3 minutes.
Okay.
You want to save that for rebuttal?
No, I'll just finish now and have no rebuttal.
Okay, go ahead.
I had 3 left of the 20.
Yeah, sorry.
Okay, that's not a problem, thank you. When you look at the property settlement agreement and the final judgment and the compliance with that final judgment, settle the property interest into between these two parties. And the husband, the appellant, did not pick up or acquire any interest or any promise whatsoever from the wife with respect to this property. His rights in the property was determined. And now the wife had to pay taxes and stuff on the property. Each party had to pay their own debts. I mean, there were contractual executory provisions to be performed in the future, but the ownership of this property, the ownership of the appellant's interest in this property was not executory. There was no promise, and Judge Lucas, I respectfully suggest that you cannot fairly read the final judgment or the property settlement agreement as saying the wife can sell the property and then she promises to pay X number of dollars to the husband. That's not the way it's written. The husband retains that interest, and there's nothing in the facts of this case where that interest ever would have been lost or challenged until more than 2 years after the wife died.
I'll be candid, my problem with that argument, hearing it now, is that in looking at your deck action, the only thing you raise and the only relief you seek in your deck action, and I'm looking at it, is the 25%, you call it ownership interest, but it's 25% of the value of the property. That's it, that's the dispute that you raised.
In the paragraphs,
I know you incorporated judgment, you incorporated marital settlement agreement.
and the allegations of the deck action specifically refer to both interests, the possessory interest and the 25%. Are you looking at the prayer?
I'm looking at the entire complaint.
Yeah, since you're out of time, I'm going to let you finish that answer, but there's no time after that.
All right, thank you.
Right, in fairness, this wasn't your complaint, but I mean, it just.
Let me refer to the paragraph number where that is.
And the only live count was count 1 because the others got dropped, correct?
Correct. Your Honor, it's in paragraph 11 of the complaint, which is incorporated into count 1. Both interests are referred to there.
Yeah. No, you incorporated it, but you didn't seek the relief. That's the problem that I'm having. But I understand your argument.
Thank you.
All right, thank you for your argument. I believe you have 20 minutes.
May I please report?
Yes, sir.
I'm Rich Caskey. I represent Kimberly Moore, who is one of the daughters of the decedent. She's a co-personal representative of the estate and a beneficiary of the estate.
Do you mind clearing up that question about the legal descriptions in the final judgment of divorce and that would put the world on notice that he had an interest in that property.
Well, I understand that now I understand that's an argument. I've got several responses to that.
I only asked it because it was raised in his argument that the title company required him to sign. Normally, a final judgment goes like this. She gets the property, if he fails to sign, here's a little description, the operation of law, judgment conveys it. Was there something more in that judgment that I don't know about?
No, and that's one of my first points,
Okay.
Your Honor, is that the way that the judgment is written, it says that the husband shall quitclaim his entire
But
right.
it doesn't
and
say
interest.
anything about he has interest in the proceeds when it's sold, he's got 2 weeks of use per year. There's nothing more in there, and there was nothing on the face of the deed, so if there's something on the face of the judgment, maybe we've got, something to talk about.
Well, the judgment says that the husband shall convey to the wife his entire interest and ownership
And
in the
he
property.
did that without reservation.
Right, correct. And it also says that if the wife chooses to sell it, I think that's the words that the judgment of the MSA uses, that he will be entitled to 25% of the net proceeds should she choose to sell it.
Well, I think
That's-
that unfortunately, it also says, however, the husband shall retain an interest in the Anna Maria property as indicated below. And I think that's the stumbling point. I mean, it
I-
seems to me that it's just inartful language
I think that's the only
of no
argument that
legal
they have.
effect.
If this is a contract right, if it's a right that arises from a judgment, it's time barred. So there are two obstacles they have to leap over. One is they have to try to distinguish it from all of the case law that's out there that says this kind of argument does not work. An attempt to recharacterize a claim as a dispute over ownership, which is addressed in all three of the main cases we've got here, Duvall, Lefkowitz, and the Scott v. Reyes case. But that's the first obstacle, is to say, this is different somehow because it's not a contract right, it's some ownership right, and we really mean it. It's a real ownership right. That's the first obstacle they have to overcome. And then try to distinguish it further without any case law to support it, that because it's real estate, that transforms it, that adjusts it and elevates it outside of the reach of the probate code. So to go back to the initial question, because I think this is important, it's the only thing they can hang their hat on, is that, well, the final judgment has a legal description, this is a property right. It's not legal title to the property. And that's a problem, because all of the cases address that and make clear that when we're talking about something other than legal title, when we're talking about equitable title, you can't get out of the claims requirements of the probate code, which are there for a reason. So the exact language of the MSA is an issue, right? Because it requires a conveyance of all the right title and interest to the wife. And then the second thing is that the allegation of the complaint, which is unrefuted, we didn't make this up, and our judge is correct, this is not counsel's complaint, appellate counsel is different than the counsel below. And by the way, none of these arguments were raised at the hearing below. This is the first time we're hearing this on appeal, this issue about ownership of a real property interest. What they argued below, what counsel argued below was breach claims, and the language used at trial below was, this was a breach not by the decedent, but by the beneficiaries of the PR. It was a repudiation of the agreement. But they allege in the complaint that the title is held by, and this is an asset of, the estate. And that ties back into Mr. Belcher's definition. He referenced the definition of the estate in the probate code. That's the problem with this, is that if you buy into this argument, which is the argument that all the case law says you can't buy into, you remove property of the estate from the reach of the probate code. And that's the result of this. That's exactly the result the Lefkowitz court was trying to avoid, and very correctly and artfully did. In the Doball case, which is, again, there's no case law that's cited here by the claimant. There is a case, though, that deals with real property rights, and it's the Doball case, the Doball v. Perez. I don't think the Perez is related at all. But in the Doball v. Perez case, that's what it's about. And it's no different than what this claimant is asserting in this action. In Doball, there was a partnership, a joint venture, and three parties got together and they said, we're going to do this in thirdsies. But the decedent, the person, the partner that ultimately ended up dying, was the person in whose name title to the real estate was put. So the allegations of their action were that even though legal title was in the name of the decedent, we had an agreement, and it was either a trust or a joint venture agreement that gave me a 1/3 ownership as a claimant. And so what I'm claiming is an ownership interest in that property. I don't hold legal title, but I'm claiming an ownership interest. And therefore, it shouldn't be property of the estate, subject to the bar date in 733-710. The trial court said, no, you can't do that. And the District Court of Appeals said the trial court was correct. Why? And it doesn't go into a lot of analysis, but what it says is, this is property owned by the estate. And because your claim affects property owned by the estate, it must be governed by the provisions of the probate code. So that's consistent with the other case law. That's consistent.
I thought your argument was something to the effect, 20% interest in the proceeds if she chooses to sell it. Does it say anything if she chooses not to sell it and it dies in her, and so the estate would have to convey title to get that to the kids or whoever the beneficiaries are?
Yeah, there's nothing in the marital settlement agreement that addresses or specifically
So in other words,
addresses.
it expired during her lifetime by inability to sell it, or she kept her under the bargain and didn't sell it, he used it when he wanted to for those 2 weeks.
I think there's an argument that once she died, that's it. He's got no more rights to the property. He's got.
Well,
no claim.
apparently there's an ambiguity here that's why the deck action.
But
was-
they didn't seek that in the deck action.
They
didn't
did.
clarify.
The deck action alleges this is property owned by the estate. And what was sought was that if it's sold, payment of 25% of the net proceeds.
They want to continue that forward.
Correct, and the wherefore clause doesn't use the word payment, which I think counsel points out. But other parts of the complaint use the word payment. The doubt for the deck action is because if they sell it, I'm in doubt whether I will receive payment for my 25%. And so this is the same as Duval. In Duval, they said, I have an ownership interest in a third. And the court said, no, this is property owned by the estate. And Duval is a case involving 733-710. It involves the 2-year bar date. Lefkowitz is an extremely important decision. It gets the analysis right. It doesn't involve a time warp, but it is exactly on point for its analysis of the operation of the claims procedures of the probate code.
Let me finish a hypothetical, and I
Sure.
freely admit this is a hypothetical, but I'm curious now. Suppose the deck action had said nothing about the 25% retained interest in the profit, the net profits from the sale of the Anna Maria property, and was sold just solely based on the 2-week interest, whatever it is that he had. Would you agree the non-claim statute would not apply in that instance?
No, I think the non-claim statute bars it. Because we're not talking about legal title. And so counsel opened his argument with.
So I want to make sure I'm clear that your argument is that the case law that has interpreted the non-claim statute has come out to say the only time we exempt property interest, and I've read the cases where it says really this is a really narrowly construed kind of construct. The only time we do that is when it's titled in Reed-Acre, not any other kind of interest in Reed-Acre.
So I don't think that's an exception. And let me give you another example, a hypothetical to illustrate it. In furtherance of answering your question, if the marital settlement agreement had said the parties shall exchange deeds by which the husband will own 75% or the husband shall own 25% and the wife shall own 75%, that's legal title. There's no claim. You own it. It's on record that you're the owner. So absent legal title, and we're talking about something other than legal title. There's no dispute in this case that the estate holds legal title, that the decedent held legal title. In Duval, the decedent held legal title. The claim was my ownership interest arises not because I own legal title, but from some other arrangement, an agreement, a
So
trust.
whether it's like I have rights to share crop, or I have rights to proceeds from, crops that may be growing on there, or a 2-week timeshare, whatever. That's a claim interest that you need to bring under the probate code, not a title interest that would be subject to the exception.
I think I agree with that. I think
Okay.
you said that accurately the way that I articulated it as well. And Lefkowitz illustrates why. And Lefkowitz doesn't involve time bar, but it involved a claim that, hey, I own this property, so it shouldn't be part of the estate. It needs to be carved out of the estate and separated out of the estate. And what the trial court did was put the property in a constructive trust, okay? And that was reversed. The District Court of Appeals said that ignores the process of the probate code. When you treat this as ownership and you treat the property as coming out of the estate, you're depriving the estate of the use of that property. There are other parts of the probate code and the creditor's part of the probate code that give the PR the authority to use all of the state property, to sell it, to pay expenses with it, to pay the decedent's taxes, the CPA, the funeral expenses, the other creditors. And what happened in Lefkowitz was when the trial court imposed a constructive trust and removed that property from the purview of the probate court, then that property wasn't available to pay the other creditors, and it gave that claimant a superior status, because that claimant could get the entire 25% of what they were owed to the detriment of the other creditors in the estate. So Lefkowitz, it doesn't apply at the time norm, but the analysis of whether something is a claim or not that's dealt with in Lefkowitz is exactly on point. And the outcome that Lefkowitz is trying to prevent is the outcome that this claimant is seeking in this court. And so the trial court was correct in dismissing it, was without error. And unless there are any other questions, Your Honors, I'll leave it at that.
All right, thank you. It's a very interesting case. We're going to take a short break, then we're going to come back and do that Ameti case and Body Montre, I think it's called. So we'll be in recess for about 10 minutes.
All rise.